tuning in. This is the Aguilar Brother Podcast. The purpose of this podcast is to give you content that's relevant for homeowners, sellers, buyers, and the real estate industry. And we love to invite guests that are going to give us key information in this market. And today we have Alana, who is an attorney, and we are excited to have you, Alana. So first of all, thank you so much for coming.
Thank you. So my name's Alana Anaya, and I am a real estate attorney. I've been practicing since 1998, and I'm also a licensed real estate broker, just so I can have street cred for my real estate, background.
There you go.
Thank you for having me.
Yeah, thank you so much. And, we're four brothers. We do real estate as a family. And I know when we were speaking a little earlier, I know you had mentioned that your parents, you grew up in the real estate industry, correct?
Yes, from day one, almost every person in my family is a real estate agent and or broker. And so I've been surrounded by real estate agents. I love real estate agents. I love real estate and just the whole circle of it. So yeah, I kind of every aspect of it, buyers, sellers, real estate agents, investments. I love it all and very familiar.
Good. And I believe you told me that your dad at age 5 told you that you should be an attorney, huh?
Yes. So while I wasn't going to be active in transactions and still in real estate, my dad said I have the gift of gab and it would be a good profession for me. And so, he planted the seed in my head and I just went full force with it, straight through to college, law school. And here I am, 26 years later.
Great. Well, we love it. And we've had a lot of our clients, ask us questions specifically for attorneys. So having you on, I think, is going to help a lot of people, give them clarity. We also want to show people the seriousness of contracts. And that's kind of the first thing I want to talk about, right? You're either you're a buyer working with the buyer's agent, or you're a seller, you're working with the listing agent. And there's a lot of contracts that are involved with it. And I think there's a lot of buyers nowadays that think they're just gonna go shopping around, go to house, write an offer and everything is good. And in a perfect world, great. Or even with sellers selling a house, there's paperwork. And in this paperwork, it's a binding contract. If you do not fulfill what's in the contract, there could be a lot of repercussions. One of them being the EMD, the earnest money deposit, which is, the deposit that the buyer makes as in good faith for the property. So we've run into a lot of, scenarios where people do not honor what's on the contract, and buyers think that they could just back out and everything is good.
And it sounds like that's when you get involved. So if Alana's getting involved, then that means that
you have the fun job.
The fun job. I think over the phone, she's like, you guys do the fun part. She deals with, the not so fun part because, one party's upset because the agreement wasn't met and somebody might be losing some money. So we want our audience to understand the seriousness of a contract and the seriousness of either buying or selling real estate.
Well, because you get the unique perspective of the marriage stage of the transaction, I get the unique perspective of the divorce stage of the transaction when it's very sticky and, the disputes happen. I can say that, one, we are in California, and California is a litigious state. We also do like our contracts here. So our contracts, different maybe from other states, is probably at least an inch or 2 inches thick by the end of completing.
So the days of just shaking hands and being like, we're in agreement, those days are over.
What used to be 1 or 2 pages, in 1970 is now about an inch thick if you print everything, maybe bigger.
Exactly.
And so it's a very comprehensive package of documents, contracts, containing legal terms, contractual terms, binding terms. And so buyers and sellers signing these documents, one, need to retain very well-seasoned, experienced real estate agents to navigate through. Very important to read everything and understand, ask questions. And if there's something outside of what a real estate agent can provide, because there are limitations, then ask an accountant, a lawyer, or anybody else that can answer their questions that they're comfortable. But not understanding and going through this process is a big mistake.
Yeah, and we see it all the time. We see agents where we hear buyers saying, my previous agent just told me to sign here, and they didn't explain to them page by page. And like you said, it's a thick thing. I think a good agent has to have the heart of a teacher where they go page by page, explaining to you the seriousness of each one. And kind of like I mentioned, the EMD, that's a very important part because let's say on $1 million home, 3%, which is typical in Los Angeles County, we're talking about $30,000.
Exactly.
So this $30,000 is on hold in escrow. Yeah. And if you are here removing contingencies, if you're here not honoring what you said you were going to do, your 30,000
risk.
is at risk.
Exactly.
And I don't think a lot of buyers understand that, you know. So let's talk about that for a bit. So let's say on a contract, there's contingency periods, right? You have your inspections. So let's say 10 days. In 10 days, you have to do all your inspections, get all the professionals, get all the right people, right? Which is a lesson within itself, right? Because it's not, let's just get it done with. You also have your loan contingency, let's say 17 days. And you go through all the contingencies. If you, let's say, even remove these contingencies, thinking that your everything is done, let's say you think that the loan is completed, you have a loan approval, you remove the loan contingency, what's at risk here? This $30,000, right? What is the process of that? Let's say, does a buyer automatically lose it?
Right. So there are all the different things that one's going to do in the contingency period, which is usually 17 days from when escrow opens. And in those 17 days, they're going to start to have physical inspections of all sorts, roof, HVAC, everything, that a professional inspector will do. They're going to have an appraisal. They're going to start their loan process right away, too, even if you have pre-approval. And that loan process usually, can take more than the 17 days. And so if a buyer is required to remove that contingency saying, I am satisfied that I'm getting a loan, they sign that contingency, that triggers that earnest money deposit from being returnable to being non-refundable and could be released to a seller.
Wow.
And so removing that contingency is a big deal. And really understanding the consequences of that, is very important. So if you remove all contingencies, that means that you better close. And if you don't, your deposit is likely to be released to a seller at some point. There's a process for that, but it's going to be released. So you're right, $30,000 on $1 million sale, that's a lot of money. And that's hard-earned money. And so you definitely want to be very cautious, listen to your agent, get all the advice you can, and be very comfortable before agreeing to remove your contingencies and triggering that deposit.
Well, let's talk about that process. So say in the event all of the contingencies have been removed, and now that all the contingencies have been removed, the buyer changes their mind for whatever reason, the loan doesn't go through, it doesn't appraise, or they didn't like their findings in the house, and they decide they want to cancel escrow. What happens to that? What's the process of the seller getting the money from escrow? What does that process look like?
Well, buyers need to know that no matter what an agent tells you, once you remove all your contingencies, you contractually have given up your deposit.
Wow.
So if an agent tells you, well, I could probably negotiate getting it back for you, that's probably not going to happen. That's a very big risk to take. And so the process would be, if you have removed your contingencies and it's technically contractually belongs to a seller, if you're more than welcome to go to mediation, which is a clause in the contract that allows you to go to a neutral and try to settle and reach an agreement with the seller. Maybe there's a middle ground. But contractually, if the seller says, I don't want to give you back that deposit, I've now earned it, you've removed your contingencies, contractually, the seller's on the right side of things.
Wow.
And you've, lost your deposit. Can I file a lawsuit? Can I put a lien on that house? I get buyers asking me that because I want my deposit back. And the answer is, if you have not performed on a contract, if you're a buyer who hasn't done everything to the black and white letter of your contract, then you're not going to be able to do that. You are not going to win, and it's going to get very expensive. So you can't use that leverage to get a deposit back.
Wow.
You really just, at the end of the day, fast forward through mediation or arbitration, lawsuits that happen, you're going to probably lose your deposit, and it's going to cost you, $50,000 or more in attorney's fees potentially.
So let's talk about that process, because we mentioned mediation. For someone watching this, they're like, well, what does that really look like? Let's say you're a buyer and you're like, let's go to mediation because I don't want to lose out my deposit. How does that process look like? I mean, are you physically in a court, or do you show up to a random Starbucks? How does that work?
Well, and I do want to say sometimes it's gray area where it's just not so black and white as to who gets this deposit. And that's really in my opinion, when mediations should take place. So one of the parties, seller or buyer, the one who's trying to get the money back, would send a written demand to the other side saying, we need to go to mediation because our real estate contract says before we file lawsuits or go to arbitration, we must mediate. And everyone agreed to that in advance. So the parties then will mutually agree on a mediator. and they'll pay 50% usually, per person for that mediator. They'll attend a half-day session. It's done usually by Zoom these days, but it can be in person. And then they'll try to resolve their dispute. Any negotiation is fair game in a mediation. So it can be any percentage, or maybe it doesn't resolve at all, and then lawsuits happen after. But it's a really good venue, which is why it's in the contract, to at least try to resolve the dispute. And in my experience, greater than 50% of the time, they do resolve themselves.
Got it.
You said it's a half-day appointment?
Yes.
Wow, why does it take so long? You go deep line by line over the contract? Is that what happens?
It's a process.
Okay.
So usually each party hires an attorney and they do a mediation brief. That's presented ahead of time to the mediator. But it's a process, and I have to say it's actually psychological and timing. You can't cut to the chase in the mediation and say, well, just give me my deposit back. If that was so easy, you wouldn't need to go to mediation.
Right.
So the back and forth, the mediator being a neutral, telling each party, this is what the contract provides, this is what you did, let's go over the details. You're at risk for that. Seller, you might be at risk at that. Buyer, please consider this. And then they go back and forth on numbers, which may take place maybe the last hour. You have to be psychologically ready to negotiate, and that's after the mediator, and a good mediator will plant the seeds and prepare the parties to negotiate.
Got it. So let's say mediation happens, you still don't come to an agreement. You mentioned arbitration. How does that look like?
So the contract has an arbitration clause, but you don't have to sign it. But, so if the parties did sign the arbitration clause, they should go to a binding arbitration, which again is another private company, which is going to be a retired judge or an attorney who's going to privately handle this dispute. It'd be similar like it was in a courtroom, in a courthouse, but it's private. If the parties didn't sign it or don't want to do arbitration, then it goes to a courthouse. Courthouses will take much longer. It could be 12 to 24 months before it would go to trial, sometimes longer. Arbitrations are quicker, but each have their pros and cons.
Got it. Okay, sounds good. So we talked about after you go through this process, obviously it's a lot of money, a lot of time in the meantime. So all this
Emotions are high.
all this to say, the agent that represents you, it's a big deal.
It's important.
It's very, very important. They have to, let you know the importance of each contingency, the importance of timelines, the importance of a contract. So we got that. Another thing I kind of want to talk about, especially in the topic of liability, was, a lot of homeowners not having a trust for their property. And, it sounds very simple. I think everybody knows about it, but it's one of those things that I'll get to it. And sadly enough, we run into a lot of those scenarios. Recently, I ran into one of our clients who we've known for years. She passed away. She was elderly. Her daughter calls us. And the first thing I told her after giving my condolences was, please tell me your mom set up the living trust. I've been begging her for years to do it. And it turns out she did do it.
We're celebrating.
We were celebrating.
We were telling you.
Obviously, it was sad, but we're celebrating that she did that because we understand. We will talk about probate in a bit.
So the process, if it's not there,
but it all turns out that it was done incorrectly. So this is the importance. It's not just having a trust and just going onto these websites and doing it really quick. The importance of sitting with a professional, and doing your estate planning. So I think this is why it's so important to get someone like Alana involved. Because you need to do it the right way. So let's say someone's a homeowner, they own property, and not just property, they have assets or, whatever it is.
Young children.
Like, what do you recommend for them to do?
Well, similar to when you're going to buy or sell a piece of property, you want a very well-seasoned real estate agent. The same when preparing a trust. If you own even one home, or you're contemplating owning one home, you want to contemplate setting up a trust. A trust is a very economically efficient way to avoid probate. Probate is expensive, it's long, and it doesn't distribute, your assets to your family as you could instruct and seamlessly allow it to take place. And so it's so easily avoidable. You save a lot of money and time just by setting up a trust. So finding an estate planning attorney that you're comfortable with is really important, and doing the trust right is even more important. There's nothing worse than having a trust like your client experience where it's not set up right and it wasn't properly funded, and now they still have to go into probate court. So that's really important too. But having a trust is kind of like having an insurance policy for everything else we have. So you're setting up that the house, should something happen to the owners, they have already set up of who's going to take place to sell the asset or have the kids live in the asset, what's going to happen. You don't have to sell the property if it's a trust. It can just transition, to your loved ones.
Yeah.
And it doesn't have to go because California law tells you to do things a certain way in probate. In trust, you have lots of choices. Anything that you want can take place. And that's huge too, to have the choices, to be able to set up your estate planning the way you want it. Specific instructions for your loved ones, for your kids, who you want your valuables to go to, in such detail. And that's really nice to have as well. But aside from that, just having a home in a trust, avoiding the probate and just being available to, to avoid all of that is really important and something that should be contemplated as soon as the purchase happens.
Absolutely. And we've experienced it. It's sad for the family. This is one of like your biggest, investments, and for it to be protected and telling your loved ones, right? You were saying that earlier, telling your loved ones and showing them by having everything ready. And I think a lot of people probably think it's going to be a lot more complicated or maybe even a lot more expensive than what it actually is. I had someone that recently told me, I don't care if it costs me more than $5,000 as long as it's properly done. So let's say someone is watching this right now and they're like, you know what, I should really do this. If they call you, what should they expect?
So an average trust just in California is going to be somewhere between $2,500 to $5,000.
Okay.
If it's super complex, it may be more. But for an average family that has one piece of property, it's going to be in that range that I just described. And as far as preparing it, I provide a list of items for someone to gather, of information and documentation I need. And if they're ready to put that together, I can have it done in a few days.
Wow. So we're talking about a few days. Okay.
Yeah, it's easy to do. It really is not a difficult thing. It's not super expensive. It's really worth it. And, as hard as one works to buy an asset and preserve it and have equity in it, giving it away in a probate situation really is avoidable and should be avoided.
Yeah. Yeah. Well, I'm glad that you shared that. If you're watching this, even if it's one person that decides to do it just because they watched it, do it. We recommend it. Get on the phone with Alana or a trusted, attorney and get on that as soon as possible. Alana, thank you so much for joining us today. I know we talked a lot of different things, and I know it's going to be a lot of benefit to our clients. So
thank you for having me.